This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Dovia. Tonight it's Ask Us Anything night, so we're opening the phone lines up. You can ask any legal question on any legal topic. Maybe you've got a legal problem developing and you'd like to be pointed in the right direction. We can help with that. Call in your questions, the 31 Law Call number 256-536-0077. You can call. You can now also text to that same number. So text 256-536-0077. You can also email us a legal question any day of the week on any legal topic, and when we get to a show that's on point, we will pull some out. We have some of your questions tonight from email. Glad to have you here tonight. Glad to have Heath Brooks here from Timberlake League and Brooks.
Good to be here. Here to answer all the questions.
All the questions.
Yeah.
I don't know if you've been watching some of the Olympics. We've got a video. We like to start the show off while we're getting all your calls locked in. We pull out some video. You be the judge in this case, the law call. We pull something off of, if you've been watching the Olympics, it is not. All right, if something like this happened at your house, it's one thing if you knew it was going on. You might have people over at your house and they start doing something you're not even aware. Are you responsible for everything that's going on at your house?
You know that you're not going to get a lot of high points for that guy. That's not something that's going to get you into the top 3 podium. But
it looks like she's lucky. Could have been way worse.
Could have been way worse. But the answer to that question is when something like that happens, you assume the risk that you could get hurt. The landowner, the property owner of the house is not going to be responsible. However, if there is homeowners insurance coverage on a house, and if she has to have medical treatment, then there is a potential that she may get her medical treatment paid for through medical payments coverage
from the homeowner's insurance.
Yes, ma'am. Could happen.
Very interesting.
That's
Don't
right.
let that be happening at your place.
No.
So call in your questions. You can call in, you can text, you can email in your questions, taking questions on any legal topic tonight. We've got this question in, this one from Lisa. Lisa had written in, I've started to look for a nursing home for my father and was told by one that I had to sign a form stating I will agree to arbitration instead of a lawsuit if they're negligent. Is that common? Is it common to have to sign something like that?
It is. It's common in every situation where you go into a nursing home. The nursing home is going to ask the family or the patient if they will sign what's called an arbitration provision. And what an arbitration provision is it is an agreement with the nursing home that you have waived your right to have a jury trial. And that can be very important. Because what ends up happening and what an arbitration is it's a private judge that is hired a lot of times and determined by the nursing home under the laws that the nursing home sets, and you get in a situation where you don't have as good an opportunity to tell your story in front of 12 people who could make a decision against that nursing home that could, one, get your loved one or get you the compensation that you deserve from the nursing home for what they caused, and number two, and maybe most important, to keep that nursing home from doing that same conduct again. It's a way for a nursing home to bury bad conduct and to get out of responsibility. Don't sign them.
Okay, if you sign it, but your loved one that's in there does not, could you sneak around it that way? You know,
the years and years and years, lawyers have been trying to figure out, and judges have been trying to figure out what to do in those kinds of scenarios. And there's the fancy legal term is apparent authority. If you are a patient going into a nursing home, chances are you're not in really good medical condition. But if you are of sound mind and you tell your son or your daughter that they can sign things for you, then they can, and the nursing home can rely upon their signature. If you are not of sound mind and the son or daughter just signs for you, even though you don't know where you are, oriented to time or place, then there is a real question about whether any kind of arbitration provision would be accepted in a court.
Okay. We're going to take a break. Be right back answering your calls and questions. We've got people on the line. Don't go away. Right back answering. It's Ask Us Anything night. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League and Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. It's Ask Us Anything night, and we've got callers waiting. We've got Eddie on the line with a question from Huntsville. Hi, Eddie. Thanks for calling. What's your question tonight?
I'm having trouble out with my homeowner's insurance company.
Okay.
Back in May when we had the last tornado to come through, I had a leak that come from my roof. It's leaking over my bathtub in the house. Now, getting the insurance company to respond, they have not responded to me at all. So, I mean, I don't know which way to go here.
Okay. What do you do?
Okay. Well, you know, Eddie, it's very common in that kind of scenario where you got a situation where you're trying to get your homeowner's insurance to work with you. You've got a problem with your house. In your homeowner's insurance, that kind of issue should be covered. That's a wind damage issue. A lot of times homeowner's insurance will try to say that's a water issue. It's not. Most likely in your homeowner's insurance it'd be covered. In any event, if they're not communicating with you, the first thing you need to do is you need to make sure you have your adjuster and your claim number's contact, and then you need to establish a written line of communication. In other words, from here on out, make sure everything that you say, either between you or the insurance company, is memorialized in writing every time you talk to the insurance company. If you can't, and what I would do is I would go ahead and I would get an estimate myself of what the damages are or what it's going to take to replace the damages, repair the damages, and then send a demand, send a request for money to the insurance company and give them a specific amount of time, 14, 30 days, to respond to you and to respond to that demand and see what you get back. I find a lot of times when you put a deadline on an insurance company, then you get a lot more of a response. The second thing that you need to make sure you do, though, Eddie, is that in the state of Alabama, we have something called mitigating your damages. And that's a fancy term for make sure that because you don't at least put a tarp over your roof or something to do a repair now, that leak doesn't cause further issues. Because what's going to happen is if that leak, say that leak causes damage to your floor because you didn't cover it with a tarp, or it causes damage to your wall because you didn't cover it with a tarp. The insurance company may say down the road, hey, look, we'll pay to repair the roof, but what we're not going to do is we're not going to pay for your floor and we're not going to pay for your wall because you had a duty to mitigate your damages under Alabama law. And that is the law. I don't necessarily agree with it, but that's what it is. So make sure you mitigate those damages. And the last thing, if you can't get with making a request and getting your estimate and you can't get any reply from an insurance company, I would certainly contact a lawyer. These are things that we have worked through in my law office before. But make sure that you contact a lawyer, tell them what you're dealing with, and there are causes of action for breach of contract against your insurance company, sometimes fraud actions and misrepresentation against your insurance company that can get you some sort of relief. It's common in our area. We have a lot of damage that comes down. Insurance companies try to get out of it.
We've got Buddy on the line with a question from Gurley. Hi, Buddy. Thanks for calling. What's your question tonight?
Yes, ma'am. I've been living here about 20 years now.
Okay.
And me and my wife got a divorce 5 or 6 years ago. But I paid her equity into the house, but the house is still in her name. And my taxes go up every year.
Okay, so you're trying to figure out what to do about the house? What you can do to get it in your name? So
no, it's in her name, but it's her daughters and everything knows it's mine because I paid her equity in the divorce papers and all that.
Do the divorce papers, so that's my area, I do family law. Do the divorce papers award you the house if you buy her out of the equity? Does it say once Buddy pays her X amount of dollars, she's going to sign a quitclaim deed and it's going to be his or something like that?
Yeah, that's what I'm trying to do is get a quitclaim deed. Okay. She wrote me like a car bill of sale that it's been notarized and said she don't want no She forfeits all her rights to this property.
Okay, so you're going to need to have somebody draw up a real quitclaim deed and present it to her. And if you have tried that and she's still not doing it, it's possible to get the clerk of court to sign off on a deed like that for you with filing something. So if she's not willing to sign the quitclaim deed that you've got drafted and presented to her to release the house to you, go see a lawyer. You're going to need to file something with the court. But it's possible, even if she's not cooperative, you can get it done, and you can have her found in contempt and maybe have her have to pay your legal fees for you.
Oh, yeah.
We've gotten somebody else had written in a question about if you have a ruling from a judge and everybody abides by it for a year, and then one party decides not to abide by it, what are your options? So that's kind of like a divorce case.
Same sort of deal.
What happens with a personal injury case when everybody's going by something and then somebody quits?
Well, you know, in a personal injury case, a lot of times you see a situation, and we've been in this kind of situation before, parties reach an agreement. There's an order by the judge that the agreement has been reached. The judge will sometimes, you know, issue an order about what memorializing the agreement, or you'll issue a settlement agreement memorializing the agreement, and everybody will go along for a year making payments and those kinds of things. You see this a lot in debt payment, repayment cases, where an order from a judge issues the terms for repayment of a debt. And then after a year, payments stop, the order is no longer being complied with. And in that kind of scenario, what you got to do is you got to go back, and you may have to have the order rescinded. Ask the judge to withdraw the order, that now you're in contempt, you're not following with the responsibilities of the order, and you may have to start litigating that case again, and may have to go through the motions of what the original dispute was. And we've seen that before.
Yeah. We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, I own a condominium. I don't have any insurance on it, and I rent it out to someone who got into, apparently he was drunk or had some drink and accidentally knocked down one of the light poles in the parking lot, and he doesn't have any auto insurance. And I want to find out, am I liable for the damages that my tenant caused in the condominium?
Interesting. Okay.
Yeah. Well, generally speaking, under Alabama law, you're not going to be responsible for the actions of your tenants.
Okay.
So, you know, there are some exceptions to that, some exceptions involving vicious animals. If you have reason to know, the big thing is did you have reason to know that your tenant was causing property damage at that point in time? In other words, if your tenant had gone out there and already knocked down a light pole and you just let him stay there, maybe there could be some responsibility for you in that kind of scenario. But if you had no way of knowing that your tenant was going to go out and was going to knock down a light pole that presumably belonged to the city or the county or the electric company, then that's not going to be your responsibility to repair in most situations.
Okay, we got an email from Nathan and Harper. They're saying that they had travel plans when all of the computer glitches happened. They went to Nashville. Their flight never took off. They missed their international vacation, and their airline is not willing to repay them. What do you think we're going to see with all of these? Is there going to be some kind of class action, you think, with all the missed flights? Lots of people.
I don't know about a class action, because I think in a class action, all of the injuries have to be the same. And so, you know, it may not be a class action, but it may have some sort of mass tort. There's a lot of players here. We don't know exactly who was negligent. What was the company and most people know that this was a situation where there was a software update by a cybersecurity company that resulted in outages that affected emails, affected businesses, but most importantly, and what we're talking about, is it affected travel. Because I think for 2 days, some airlines were completely grounded. I know for a certain period of time, every airline was grounded. So you had thousands of canceled flights, billions of dollars potentially lost in revenue, and we still have ongoing problems from this. So are there going to be lawsuits would be the big question. I would say yes, most likely. There are going to be some lawsuits against this cybersecurity firm and any kind of negligence that they may have exhibited or that their employees may have exhibited. And the other thing that we may see is that there is some federal law that requires airlines to repay passengers for the ticket costs in the event that the flight is canceled. There are some exceptions to that rule, but I imagine that there are going to be a lot of passengers that are going to be trying to get their money back from various airlines and may have to get into some litigation to do so.
It's going to be interesting to see.
And then the airlines are going to blame the cybersecurity people. They're going to try to get their money back. So we'll see how it goes.
It'll be a series of lawsuits.
That's right.
Okay, we got a text message. Me and my fiance have been engaged for 18 years. In Alabama, is that considered common law marriage? Okay. A couple of years ago, the Alabama legislators got rid of common law marriage. So if you weren't already grandfathered in as common law married, you can't get it anymore. And to be common law married, it's not about a length of time. You could live together for 18 years. So even if you were living together before the law changed, living together is not enough. It has to be that you've presented yourself out to people as being married. So did you introduce each other as husband and wife? Did you file taxes jointly? Did you tell people, if your closest friends would have said, oh, I thought they were married. They said they were married. They called each other. That's when you get in common law. And even that, unless it was grandfathered in before the law changed a couple of years ago, can't even get that in Alabama anymore.
So I have a question. So if I am in 2002, I'm telling all my friends we're married, we've got a checking account together, I got health insurance, but we haven't really tied the knot. But this is 2002, and we're still together. Am I considered married now?
Could be. You could be. And if you wanted to separate, you might have to, one of you can file for a divorce.
Okay.
A lot of this was based on what if records got burned down. So you couldn't prove you didn't have a marriage certificate back in the day when things weren't recorded digitally and something like that. What would you do if you can't prove it? But you've been treating yourselves as married, so that's where some of it started.
I got you.
Laws change over time, though. It's getting a little bit different. We've got Emma on the line with a question from Moulton. Hi, Emma. Thanks for calling. What's your question tonight?
Yes, I have a grandson that's in Decatur jail. He's got his own drug. I mean, they picked him up this time it's because he didn't go to a meeting or something. And I know, you know, that in a way it's his fault. But I have started getting him in down at the Foundry in Bessemer. And I've got it paid for all of his teeth to be pulled and his temporary plate put in. But the day before he was supposed to go to the Foundry for that, he got picked up again. And now he's up there in jail in Decatur with 2 abscessed teeth. Every one of his teeth need to be pulled. And I don't know how I can, if there's any way I can get him to Bessemer for them to finish the work that's already paid for. The money's up there.
Emma, does he have a lawyer?
No, I can't afford one. I'm 89. I'm his grandmother, and his mother, and you know she can't.
A lot of cases, he might be able to get an appointed lawyer. Certain kinds of cases, you can get somebody appointed.
That's right. If it's a potential felony or a crime that is potentially over a year in prison, then the court must appoint you a lawyer. And there are certain circumstances where that can happen. And then the unfortunate thing is certainly he's in jail, and the prison system maintains a requirement to give him the proper medical care. So you know, and a lot of times you got to be a squeaky wheel and make sure that the jail knows that there are some issues ongoing with his teeth. Sometimes you can get the jail to allow a limited release to go and get the dental work done, and there is a procedure that you can go through to get to that point. Unfortunately, though, a lot of times it is waited out. You know, if it's not a situation that is causing potentially imminent harm to his life, then a lot of times the jails won't let him go get treatment. But certainly, I would ask and see if they could get a limited release to go down there and get his teeth fixed.
Getting a lot of family law kind of questions tonight. We got this one. From text message. Thanks for all your text message. If a relationship ends, do we have legal rights to each other's individually acquired property if we were not legally married? Well, if you're not legally married, then you don't have rights unless you've got some sort of a contract. So we could own something together. We're not married to each other, but if we own it jointly, or if we make an oral agreement that that's how we're going to own it, that's a contract, but you'd have to take it to court to fight over it. If you're living with somebody long term, think about that. If you own something in your name, it's going to be yours. If he owns something in his name, it's going to be his. And unless you can prove otherwise, if you're not married, judges don't want to give you rights to that.
And if it's not in writing, it's important because there's some pretty significant laws in the state of Alabama that if you have an oral agreement or one person says that there's an oral agreement, but there's a written agreement that disregards that oral agreement. For instance, if there is a car that you and your partner have agreed to own jointly, and you're not legally married, but on the title, your partner is the only person on the title. That is a written legal statement that he or she is the owner, and even though y'all may have orally agreed to own it together, the title is going to hold every single time.
Yep. Get it in writing.
Yeah,
get it in writing. Got an email from Claire. Claire says, a neighbor who rides with me to work was injured when I got in a car accident. Am I legally obligated to pay her medical bills?
You know, that is a question we get a lot in my practice of law. And the state of Alabama has something called the guest passenger statute. And what that means is that if you are a guest in the car, if you and I go and we're just going to go pick up some food at the McDonald's, and there's no benefit that you're providing me, and I'm driving and I run a red light, then I'm not going to owe you anything for my negligence. You're a guest in my car. Now, if you give me $1 for gas, you stop being a guest and you start being a paying customer. And so now, if I'm negligent and run that same stop sign, I may have to pay you for the damages I caused you if it's an injury. So the question would be, Claire, if you are paying every morning to be taken to work, then you are not a guest under the guest passenger statute in the state of Alabama. You're a paying customer, and if you're if you injure your passenger or your passenger injures you in that kind of scenario, then you could be responsible.
You want to talk a little bit about how to pick a lawyer? Got questions about how to pick a lawyer, and sometimes it goes wrong.
You know, that's true. And one of the things that we see in the legal field is that sometimes lawyers take on cases that they're not familiar with. And that's okay in some scenarios where, you know, a lawyer can get up to speed and take the time that is necessary to learn what the law is. But when you are choosing a lawyer, you need to make sure that the lawyer that you choose, if in a particular case, has some experience in that case. You know, if that's a premises liability case where, you know, you were injured in a store, then you need to make sure that the lawyer that you hire has handled those types of cases before. Or if it's a case involving a family law issue, you know, you need to make sure that the lawyer that you hire is familiar with family law issues. Otherwise, you run into trouble with an inexperienced sort of lawyer, particularly if the lawyer doesn't take the time to learn the information. Always best to go with somebody who knows that
Talk to your friends who've been through it, see who they used and who they were comfortable with and what got good results with. Always good to ask other people. Good
point. You need to be comfortable with the lawyer that you choose because, you know, the cases, when you get involved in a lawyer, these cases can be very, very long. They can take years sometimes, and you're going to know this person for a long period of time. So you've got to be comfortable with the lawyer that you hire so that you can trust each other as you move through the process. It is a bifurcating trust. I mean, it's a reciprocal trust.
Yeah.
You know, you've got to trust your client has to trust you. It's got to be on both sides of that.
We're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. See you in just a minute. If you didn't get your questions answered tonight, here's how to get in touch with Heath Brooks with Timberlake, League & Brooks in Huntsville, 256-536-0770 or 800-804-2502. They are personal injury attorneys, so that's everything from medical malpractice to nursing home negligence to car accidents, 256-536-0770. Also check out law-injury.com.
And this is Sharon Doviet. She does all things family law, child custody, divorces. She can be reached at www.sharonfamilylaw.com or 256-539-7337.
We didn't tell people time limits, statute of limitations to file a lawsuit in Alabama for these kind of things?
2 years from the date you're injured.
2 years, 1 in Tennessee. We'll see you next week.